I'm going to have to drag this back to the US as well here. Greg, Cindy, if you want to come in after Greg, but just a legal angle to some of this, would I be right to think you're both advising clients to keep detailed records of all tariffs paid just in case these lawsuits against tariffs and presidential power succeed at the Supreme Court?
I mean, absolutely on our side, I think, irregardless of the court cases, it's just good practice anyway, of course, to have, meticulous trade documentation and make sure that, you've got not only, what did you submit, but some rationale on why did you submit it. On our side, we're of course making sure that our data is clean, that our declarations are defensible, and that we're in a position, regardless of what happens, right, with the court cases, to assist our customers, whether that's with future refunds or challenges or questions that they may get from CBP. That we've got a proper record keeping on our side to support them in whichever way that they may require.
I'd be interested, Cindy. I mean, please follow up on that. I'm as a listening, I'm thinking, if you're one of the brokers here and you help people to keep track of all of this, do you get a bonus if they get a rebate?
Well, it depends on how they issue that rebate, right? If you have to do an additional filing, brokers don't work for free like anyone else, so they'll get a fee for doing that. But I've been advising, customers kind of a few things. One is review what your broker is doing. Make sure that they are claiming it correctly, and that's because the custom systems, we're used to them having very robust edits and telling us as we transmit the data, hey, you got something a little wrong here. And with all of the stacking tariffs, the customs system in the US doesn't do that anymore. So it's easier for a broker to make a mistake. And there's no back end to catch it unless you have a system like CargoWise who has put some of those edits in and can help you recognize when you're making an error. But it really does depend on the information that the importer is giving. So the first thing is check what your broker is doing. The second, as Greg mentioned, is make sure that you have all of the information as best as you can and documented while you're making that decision, especially when you're talking about splitting those component or derivative level products out. You have to have a rationale for that. And then the third thing is check ACE. The CBP ACE system has records of all of the transactions. Make sure that you are taking those in, recording what is there, comparing it to what the brokerage records say, comparing it to your own records. And then the final thing is track finalization of the entry or liquidation. We are seeing that liquidation, if a broker makes a mistake or an importer says, hey, I gave you the wrong information, let's do a correction with the customs system, that automatically liquidates when customs takes that action. And that's been a process for many years. However, it didn't matter. Now it matters. Now, if you have a liquidation and it could be possibly subject to this court case, you want to make sure that you're filing a protest. So watch the finalization or liquidation of your entries to make sure that you've kind of protected that right for a future refund.